Mga kachabs, mga andan mig biryani mga kachabs. Niluto ni Ate Jen mga kachabs. Giamot-amotan ko ni namo tanan. Kaning giluto ni Ate Jen. Mo lagi kay nalimtan ng Coca-Cola mga kachabs. So, nag-orange na lang yan ang mga kachabs. Wala mi Coke. Nagwa mi soft drinks ba? Ana ba? Ana na siya mga kachabs. So, ano na siya mga kachabs. Yara mi sa salog ni kaon mga kachabs kay daghan man mi. So naglatag lang mi og plastic mga kachabs. So, mga kachabs, init pa di ba? Gaso-aso pa. Thank you Ate Jean sa biryani.
The Chamber authorised Mr. Duterte to follow the hearing at a distance. His counsel, however, is present with us in the courtroom. Thank you, counsel. Please introduce yourself.
Definitely honored. I am Salvador C. Medjode, counsel for.
Thank you very much. Thank you very much, counsel. I will now introduce the Chamber. By my side, as the judge, as you are receiving what I'm saying in English. I understand that you are at ease in the English language and that the interview yesterday at the detention centre was conducted in English and that you did not deem it necessary to request interpretation into any other language during this interview. This said, I would like firstly to confirm your identity. Could you provide us with your full names, please?
Rodrigo Roa Duterte. First, middle name is Roa. Surname is Duterte.
Thank you very much. What is your date of birth?
Okay. Can we request that the question be? Don't think you heard it. Thank you.
Repetition from the English. What is your date of birth? Yes, thank you very much, counsel. I was asking Mr. Duterte what his full names were, and then I subsequently asked him what his date of birth and what his place of birth is. Is that right, counsel?
Today is March 28, 1945. I was born in the present is
Thank you very much. As a preliminary point. Very well, thank you, Mr. Duterte. As a preliminary point, it is useful to clarify the nature and limited scope of this first hearing. Today's hearing is neither the start of the trial, nor is it a confirmation of charges hearing. During today's hearing, no evidence will be collected or presented, and the issues of Mr. Duterte's will therefore not be addressed. In accordance with Article 61 of the Rome Statute, the Court's Founding Treaty, and Rule 1.1.1 of the Rules of Procedure and Evidence, the main purpose of this initial appearance is to answer three questions. Firstly, the Chamber must ensure that the person who was the subject of the arrest warrant has been informed of the crimes of which he is accused. Second, the Chamber must ensure that this person has been informed of his rights as recognised by the Rome Statute. Third, the Chamber must set a date on which it intends to hold a confirmation of charges hearing. The Chamber notes that your counsel, Mr. Duterte, filed two motions, one in relation with today's hearing, and you may be aware that these two motions have not been accepted by the Chamber because of the nature of today's hearing. No further discussion on the matter is necessary during this hearing because, as I said at an earlier stage, the aim of this hearing today is to introduce the parties and to ascertain the charges and to set a date for the confirmation of charges hearing at a later stage. With regard to the first point, I recall that Mr. Duterte has received a copy of the warrant for his arrest and that a redacted version of the prosecution's application for the issuance of the warrant of arrest is public. I will now ask the court officer to read the charges against him. The charges will be read in English. Please, over to you, Madam Courtroom Officer.
Thank you, Madam President. Your Honours. On 7 March 2025, Pre-Trial Chamber 1 concluded that there were reasonable grounds to believe that Mr. Duterte is criminally responsible pursuant to Article 25(3)(a) of the Rome Statute as an alleged indirect co-perpetrator for the crime against humanity of murder pursuant to Article 7(1)(a) of the statute as follows. A. Murder of at least 19 persons, allegedly drug pushers or thieves, killed by members of the Davao Death Squad in various locations in or around Davao City, Philippines between 2011 and 2016. B. Murder of at least 24 persons, alleged by criminals, such as drug pushers or thieves or drug users, killed by or under the supervision of members of the Philippines law enforcement, sometimes with the assistance of persons who were not part of the police, at various locations in the Philippines between 2016 and 2019.
Thank you, Madam Courtroom Officer. Mr. Duterte, I'm not going to ask you to stand up because I know your condition, so I'm going to allow you to remain seated. You have just heard the reading of the charges, which are in accordance with the content of the arrest warrant you received. This means that you have been informed of the crimes of which you are accused. And this concludes the examination of the first point mentioned above. I will now turn to the second point, which concerns your rights as a suspect before this court. I will summarise some of these rights, which are of particular importance at this stage of the proceedings. Those rights are as follows.
A sovereign country was bundled into a private aircraft and summarily transported to The Hague. To us lawyers, this would be called an extrajudicial rendition. To the less legally inclined, it was a pure and simple kidnapping. My client was denied all access to legal recourse in the country of his citizenship, and this all in the nature of political score settling. Two troubled entities struck an unlikely alliance. An incumbent president who wished to neutralize and choke the legacy of my client and his daughter on the other hand, and a troubled legal institution subject to delegitimization and desperate for a price cuts and a legal show today on the other hand. With this in mind, it is not surprising that my client was abducted from his country. ICC private jets do not drop out of the thin air. That jet which received my client was coordinated in advance. The UAE is not a state party to the ICC and has no obligation to operate the port. Yet my client sat in transit in that country for more than 5 hours. I invite the registry's representative to present today in court to explain to the judges exactly how they believe this transfer was anything other than a gross abuse of process. Given the precipitous arrival of my client, an elderly man with debilitating medical issues, hard of hearing and poor of sight, he was taken to a hospital for observation. Only this morning have I met him for the first time with less than an hour to discuss legal issues. I have not been able to present him with a hard copy of the arrest warrant because we were not supplied with such. I have not even been able to explain to him what the prosecution requested when seeking the issuance of the arrest warrant. This is because the chamber only established a redacted version of the prosecution request last night. Other than to identify himself, my client is not able to contribute anything to this hearing. Most importantly, he is not able even to tell you that he has been informed of the charges.
Of the Rome Statute, that he is aware of his rights, that he is also aware of the charges against him. The registry saying that he is also aware of the warrant of arrest in the English language and that he is addressed in the English language. Once again, you have the possibility of these charges being read in English, which was the case today. I have read to you in the French language the rights that he has, Mr. Duterte, before this court, and I'd like to specify once again that this is an initial hearing. In order for Mr. Duterte to be aware of his rights and the charges against him. And then there will be a full procedure that will unfurl leading up to the confirmation of charges that will enable Mr. Duterte to raise all the matters that you have just raised with regards to the warrant of arrest, with regards to the crimes committed, with regards to the charges, and any other matters associated with his arrest. And matters of jurisdiction of the court. You have the opportunity to do this throughout these proceedings leading up to the actual confirmation of charges hearing. Now, counsel, with regard to your request for another hearing to be held next week, well, your initial request, that was, this was not accepted by the court. Now, you have seen the two decisions of the court that have been disclosed to you, and you are aware of the fact that the two decisions were refused. And this is right into the fact that this first initial appearance hearing does not need much preparation, as I have said to you on a number of occasions. I am now going to move on to the third stage, which is to set the date for the confirmation of charges hearing.
Sa powder, sa biryani, halang mag-biryani. Mix naman tayo ng Kaya sa sawa namin nakalang.
In out. In out, in go.
Ano na tayo magluto ng ganyan?
Yung kobra lang,
Hindi, yung white lang, yung white na ano.
Ano, white rice? With rice? Isa may lumang yelo, medyo dito, di ba?
Kaya
Tumira ka,
alam,
ano?
di ba para sa aluman
So,
siya?
trial, information. Just sa internet, yung mga research ko this past 50 years, sa mga kasalite nga, sa pagdito trial, sa mga siya ako ang na-discover. Ayaw, enough ba siyang information. Basta mga siya na-discover tayo. So, ang pinakauna na president, yung pagdito tayo dito sa Hague, sa Netherlands, na King siya tayo. So, ang pangalan ano niya is Slobodan Milosevic. Presidente siya sa una sa Serbia. So, dahil siya yung mga kaso dahil ng anak, yung mga sa humanity, tapos siya kaso ng katubag. As good. So, dahil siya niya yung notice, May 27, 1999. And so, the first time to dahil sa mga head state na receive sa ICC. Tapos, na-arresto siya sa mga Serbian police dahil kay April 1, 2001 na dahil. So, like, after 2 years, kaya nakabot sa ilang notice. Tapos, extradite siya madulong sa Hague kay June 28, 2001. So, imagine the red notice na kay naabot sa 1999. Tapos, ginatid siya kay April 1, 2001 na. Tapos, gitan siyang pagdakot dahil kay after 2 months pa siya gisend dito sa Hague. Pero kay Digong dahil, kung sino itabo dahil, ang abot sa red notice dahil, karong anlawan na abot ang red notice dahil. Karon po siyang anlawan yun dahil, di sa dahil. So, kinagin siya, after 2 years pa siya bago gisend dito sa Hague. Pero si Digong dahil, wala rin. So, dito hours dahil, pag-abot sa red notice, send yun dahil. Tapos ako mag-search ko dahil, ang kini siya na president sa Serbia dahil, kaya namatay na siya dito sa sulod siyang selda. So, he died sa iyang prison sentence on March 11, 2006. 4 years, 8 months, and 11 days after being taken into custody. So, imagine dahil, 4 years dahil, naa siya dito sa sulod niya. Wag ko naman ang iyang trial. Ina siya kabugay dahil. Tapos pagkamatay niya dahil kay, wala pa siya kanang verdict dahil. Wala pa resulta sa iyang kaso dahil. Wala pa. Tapos anak pa sa iyang cause of death.
Wala.
Cause of death dito tayo. Ang cause of death daw niya is heart attack. Kailangan sa history sa high blood pressure, heart problem. Tapos, few months pag yun dahil sa iyang pagkamatay dito, she claimed magiguluan siya dito sa sulod sa iyang selda. Kung ano yung giingon dahil, few months before siya na-dead dahil, kaya siyang giluan siya dito sa sulod sa iyang selda. Tapos, ano pa dahil, reports later found that he had traces of rifampicin, an antibiotic that can reduce the effectiveness of blood pressure medication, worsening his condition. So, kapila po din siya nag-request by niya, kanabitaw, mag-check up sa gawa, sa nagugis sa iyang condition ba? Tapos wala yun siya gi-grant din sa court dahil. Tapos karon dahil, kaya nag-search ko dahil, anak ko nga, hindi ba pwede nga ka nang magulat na kasi mong trial outside sa Hague na kaprisuhan. Dili siya dahil. Once naana ka sa sulod dahil, di na kanila kabawsin di dahil, until na mahuman ang imong trial dahil. Ina-upira ko ang trial dahil, kay bulan na imong hulatun dahil, dahil tuwig dahil. Kunya, anak ko di ba, kung biskitan dahil, syempre dahil, pila na ng iba si Digong dahil, 80 na dahil, pila ka tuwig na trial dahil. Pero ang iyang case kaya sa pwede, ang iyang nag-uis kaya sa gira siya ba? Tapos share ka na ko dahil second head of state dahil ha, na yung deliver dito sa Hague dahil. So kini siya dahil, ang pangalan ano niya is Lauren Gbagbo. Like, kini siya ang president sa siya is Ivory Coast, country na siya sa Africa. So kini siya ang ikaduha na head of state nga na-stand dito sa Hague. So November 23, 2011, nag-issue ang ICC sa iyang arrest warrant. So April day ha, nga arrest warrant, pero nag-sabite siya dahil dito sa Hague dahil November na dahil November 30. April na abot ang iyang warrant. So May, June, July, August, September, October, November. So after 7 months, bago pa siya naabot sa Hague dahil. So nagligong dahil, pag abot sa warrant dahil, bilit to send, wala na yung 1 day. Like, gibuga rin pagawas, diba? Anak sila kamantas. So same gihapon dahil, ang case food niya dahil is like against humanity, ana. Tapos paminaw dahil, diba nag-start ang iyang kaso, November 30, 2011. Na-acquitted siya dahil, sa iyang mga sala dahil, sa iyang kaso.
Busog na ang tanan.
Follow after ilang years. After 8 years and 1.5 months. So na-acquit siya, bago lang dahil.